Let's get some reaction from legal expert Elton Hart. Elton, thanks for joining us this evening. A total embargo does seem a bit outrageous when it comes to cameras or her being televised in court. We know that the witness we are talking about is one of the women that was in the house the night Senzo Meyiwa was murdered. That's basically what we know so far. And of course, we also know that she is a public figure from what we know. What are the odds here? Are the odds actually in her favor or totally against her? How will the court rule, you think?
Now, obviously, if I look at it, and I look at it very nicely from the Van Breda case. The Van Breda case outlined clearly what is the procedure, and the default position is now, currently now law, is that cameras and videos is allowed in the courtroom. That's the default position. And for the court to depart from that default position, as stated in the Van Breda case, there should be an inherent risk to the safety and security of a witness. And that is then weighed against the right entrenched in Section 16 of the Constitution of media houses. So that two rights has to be played off against each other, and looking at Section 34, access to court and open justice. And we weigh up the public interest against this individual's interest. And today we saw, while the lawyers for multimedia, MultiChoice was busy actually advancing arguments on behalf of media houses, the alleged public figure was then again on social media, busy with tweets about this case. So if you fear for your safety, why would you still engage in such activities? It's, for me, this is just a delayed tactic. And I think also what the state via advocate Baloy should have advised this witness of what the correct procedures is. Because if she doesn't want to come and testify, because it seems like she's now sort of holding a gun to the state's head, if they don't stop the televising of my images or the trial when I'm testifying, then I'm not going to come and testify. She doesn't have a choice. Just subpoena her to come. And if she doesn't come, issue a warrant of arrest. Simple as that. The odds is stacked against her as I see it from where I'm sitting.
Yeah, because she does say if you know, the cameras will be in the courtroom, that she won't testify at all. Is that something that she can say, that her legal team can fight, that she will not be testifying if the cameras are there, if the court rules against her?
No, if she does that, if she comes and she says she doesn't want to and she recants, then they can use certain sections in the Criminal Procedure Act pertaining to it, from Section 189 to 192 of the Criminal Procedure Act, where they can now first go and say that, okay, you are recanting, and then we can then work from there to say, now you are sort of a hostile witness, and then we can work with you in that way. But she cannot, because she has made a statement under oath about her knowledge pertaining to a crime that was committed, and that in itself places a duty on her. So her legal advisors, whoever they are, they can come with all sorts of weird and wonderful explanations, but testify, she's going to testify. She's sort of half in a corner, and I think the state was supposed to advise her, because they have a duty to consult with their witnesses beforehand and say, listen, yeah, this is what you are saying, but this is the law. And we cannot say, we can say an individual's right outweighs the general public's right to know exactly what happened to one of our national assets. A captain of the national team was killed, and she wants to say, I don't want to speak. You have evidence of the offense. Why don't you want to speak?
Yeah. And I mean, if we want to argue about safety, then we can also argue that, you know, the safety of the court officials and the defense, you know, everybody who's been on the stand already, their safety might be in jeopardy as well, if you want to take a look at that. But also, you know, from a heartfelt perspective here, I mean, it's just, you know, fair, I guess, for the families, and if, like you said, it's a Bafana captain that was killed. It's just fair that we get everybody's, you know, testimony, as we have had now so far. Maybe the camera shouldn't be on your face, but at least we can hear everything live. I think that's just, you know, from that perspective, to the families and to the rest of South Africa, a fair ask.
No, that's definitely so. And it's in line with our constitution, that principle of open justice. it's there. It's not. They say that justice should not just be heard, but it should also be seen. So it means that people that's not technically in Gauteng, but has an interest, like his family members that can't afford it to be in Gauteng, they want to know what has happened to their child. And now to come and bring an application as flimsy as this one to say that I don't want to be seen, but the media can take pictures of me in the corridor, on the walkways and everything. People will still see you. People will know exactly who this witness is. So being confronted by people or the public of what you testify, it comes as part and parcel of our law. You cannot say that I will be under pressure. All of us are under pressure here because we want to know if our justice system is working or it's failing us. And also, the public prosecutor has pressure on him because he has to execute the public's mandate. But the defense lawyers has to also make sure that they ensure their client's rights. Everybody's under pressure. So your pressure is not more important than somebody else's pressure. And here it's like public interest versus your personal interest. And then in terms of the Constitution, Section 36, I think the public's interest way much more heavier than, we're not saying ignore your concerns, but that is just concerns. There's not even evidence, not a shred of evidence that she put on the table about her safety, the pressure, nothing. It's just mere empty allegations that she's making.
Elton, let's talk about the court case thus far. We've heard some very contradictory testimonies in this specific case. From what you've seen and your observations thus far in the Senzo Meyiwa trial, what is it that you can take from this and going from what we've heard and even going forward?
What I'm already seeing is like it's very bleak for the state at this point in time because you have Tumelo Madlala that testified in a certain way, Mtokozisi Twala that's testifying in a certain way, and there's already statements that we hear from Zandile Kumalo and Kelly Kumalo that is going the other way, that is sort of half contradicting, and it's on critical things because Tumelo Madlala and Mtokozisi Twala said the intruders was always just in the kitchen. The second intruder never even entered the house, while the other two is already saying that the second intruder was in the room, and we don't know how they're going to testify when they are put on the stand as to how they will turn or change their statements. But this is already like, it shows there's contradictions, and obviously our law is based on the accused there must be beyond reasonable doubt that they have committed the offense. And I already see a bleak picture, and we'll never know what has happened to Senzo. And I foresee that there must be a not guilty verdict for these accused people. That's what I speculate. It's looking 60-40 for me at this point in time in favor of not guilty.
Thank you so much. Of course, legal expert Elton Hart, always good to have you on the show. Thank you again for joining us. Still to come.